to be above the fray and transcend what is this ideological trench warfare in pursuit of the law, whether you have a more living constitutional theory or you're more of a textualist. There may be ideas associated with those approaches, but their fidelity is to the law and the Constitution and not to a political convention or a political party.
Well, let's put it in perspective. At the United States Supreme Court, which hears maybe 60 cases a year, most of the cases are resolved without much dispute. And the 10 or 15 that are controversial, we all know about and we hear about, but most of the cases are not so controversial. The federal courts hear just a tiny sliver of the cases that go to court in this country. Most of the cases are in the state courts, and most legal issues never go to court. So the legal system is actually not in jeopardy in quite the way that your question suggests. At the same time, access to law is in jeopardy. And here I see, from my vantage point as the vice chair of the Legal Services Corporation, a serious crisis going on in this country. 80% of low-income people have no access to the civil justice system, meaning anything but criminal law. So whether they're dealing with access to veterans benefits or a protective order to guard against domestic violence or a way to guard against the loss of their home due to foreclosure and unscrupulous behavior by mortgage providers, there's no way they can afford a lawyer. And that's a serious problem because that, again, erodes respect for law. It erodes the prospects for justice. And if we also put that together with the privatization of justice, eBay resolving over 1 million disputes last year online without a person involved at all, just with an algorithm. Private companies requiring mandatory arbitration rather than access to court for the resolution of consumer disputes and so forth. If we see more and more ways in which ordinary people cannot enforce their legal rights, that's a more serious problem than the politics that you're describing.
So how is the board on which you sit attempting to resolve this severe inequity?
Well, the Legal Services Corporation, which was created under the presidency of Richard Nixon, reflected a bipartisan view with the leadership of the American Bar Association that law is important for advancing democracy and securing liberty for every person. You think about the Pledge of Allegiance, liberty and justice for all. This is at the core of the American creed. The creation of the Legal Services Corporation was a recognition that low-income people have trouble being able to afford a lawyer. Its funding has gone up and down. It's created by the federal government. It's funded by the federal government, although it's a private nonprofit organization. The members of the board are appointed by the President of the United States, confirmed by the Senate, where it's kind of an odd duck, kind of a public-private entity. How the board right now operates is by continuing to try to work with the Congress to secure sufficient funding for the grantee organizations across all of the states, and also to deal with just the basic fact: we will never have enough money for lawyers for poor people. So one of our major initiatives has been to develop new technologies that can help people without a lawyer navigate the legal system and help sort the cases that really need to have a lawyer from those where an individual with some help online may be able to manage by him or herself. The technology innovations are fantastic. For example, interactive websites that allow a veteran and members of a veteran's household to be able to get their questions answered so that they aren't stuck languishing with no response from the bureaucracy. I think that there are great innovations in many other fields where law could learn. It's happened in medicine. It's happened in just simply consumers' experiences with large stores. You can go online and you can have actually a fairly intelligent conversation with a computer to sort out what your problem is and at least get some answer or more efficiently get to a human being. And I'm excited to see the work that Legal Services Corporation is supporting all over the country in this vein.
But you don't want to veer too much towards the eBay algorithms in adjudicating this, right?
Well, I
mean,
think
in terms of the broader picture of the democratization of law, because you're saying the sheer volume doesn't allow for that kind of due consideration across socioeconomic lines.
I should be clear that the eBay dispute resolution receives rather high marks from those who participate. I think the problem is if we foreclose any public justice, then we cut off the virtuous cycle that's represented by law, where there are public decisions which then deter misconduct in the future. We need to have both. We need to have private dispute systems, and we need to have public dispute systems.
Or even just public scrutiny.
Public scrutiny would be an advance.
I think that this question of democratization is very relevant to your focal point, your focus as a scholar on racial equity, what you've studied from Brown onward. You were a clerk for Justice Marshall, Thurgood Marshall. You've seen the evolution of Brown in both the betterment of American society and maybe the opposite of that in combating a resurgence of racially charged legal thought and political action. And I'm really talking about the disenfranchisement of the American voter. Can you weigh in on that subject and how you see Brown's relevance today?
Well, there are so many different elements packed into your good question. The status of African Americans in the United States following America's original sin of slavery continues to be simply unsatisfactory. The nature of economic disadvantage in creating basically two Americas. Those who have access to resources and those who don't have very different experiences with the justice system, with healthcare, with education, with every aspect of life. In addition, the role of courts as an instrument for trying to rectify injustice, with perhaps Brown versus Board of Education being a high watermark, but really an unusual use of the courts to go out ahead of public opinion. Compared with the use of the legislative process to try to express the views of the majority. And another aspect of your question that I think can't be denied is whether or not we even have a we in this country at this moment.
Is
there a we? Is there a sense of a common purpose, a sense of a common identity, a sense of a common mission?
Do you think that in terms of the pendulum that swung from Earl Warren's court to William Rehnquist's court, that has some relevance to this conversation of how we view and how we treat people of color in this country?
Well, of course. So let's talk about the legacy of Brown versus Board of Education, which of course didn't come out of nowhere. It reflected over 20 years of practice and litigation efforts by leaders at the NAACP Legal Defense Fund, including my former boss, Thurgood Marshall, and many other very creative and courageous lawyers and leaders, building on step by step the challenge to the prior decision, Plessy versus Ferguson from the 1890s, where the Supreme Court had ruled that the Equal Protection Clause of the 14th Amendment does not guarantee integrated experiences. Instead, Plessy said, separate can be equal. That case arose in the context of railroad cars, which literally sorted people by race, what car they could sit in. And it wasn't just separate cars. The car reserved for Black Americans was far inferior. The challenge to that doctrine focused over time on schools, on public education. And what Thurgood Marshall said to me was, we said, separate but equal, okay, show us the equal. The strategy was to actually look at the expenditures on schools and to show, which was not hard to show, that the amount of public dollars going into the schools for Black children was a sliver of the amount going to the schools for white children. One of the strategies, therefore, was to integrate the schools because, as Justice Marshall used to say, you can't have differential expenditures when the kids are sitting next to each other in the same classroom. Of course, another goal was to tackle the ideology of racial superiority that was reinforced by segregation, with one of the pivotal cases coming out of the University of Texas, refusing to admit black students to the law school there. The University of Texas said, we'll create a separate school, a separate but equal one. The school was such a sham, it was easily rejected by the Supreme Court. It was one desk in the courthouse. It was not a school. It didn't have a library, it didn't have a faculty. So separate but equal was easily demonstrated as a sham in that case. Ironically, today, University of Texas, we have a case pending in the United States Supreme Court about whether the University of Texas use of race as one factor in admitting students violates the Equal Protection Clause. Now, somewhere between the earlier decision and the current pending one, the country has changed, and the country has changed in a couple of ways. Brown versus Board of Education mandated the dismantling of segregated schools. Nothing happened in the country other than resistance for about 10 years. After 10 years, actually under the leadership of President Nixon, a Republican, the federal government began to enforce the law. There was a backlash. There was a serious backlash, and he changed his own views on the subject, and he appointed to the Supreme Court individuals who slowed down desegregation. In the meantime, the Congress acted and enacted the 1964 Civil Rights Act, and that shifted the focus on desegregation to other branches of government. We've had a mixed story ever since. Probably one big turning point happened when actually desegregation efforts in the schools started to bring in suburban schools in the north. And the Supreme Court said, no, you can't do that if you haven't shown that there was an original act of discrimination in the suburban schools. That contributed to white flight, with many whites with any resources leaving the public school systems either by moving to the suburbs or moving to private schools. The backlash goes on today. We can talk further about it, but in some very important respect, it does reflect the impact of politics on law.
Looking at the backlash that is evident in our politics against what was perceived as a preference for or preferential treatment that minorities would be getting, how do you see the constitutional framework evolving in a way that undermines whatever constitutional legitimacy that idea has, that we were giving a preference to people of color and now we have to somehow undo that preference?
So the idea that there are preferences involved is itself, of course, one of the big controversies in the issue of race relations. To dismantle segregated systems may look like giving a preference, but I don't think it is. And the problem that has emerged in schools in particular is the continued exclusion of disadvantaged people from educational opportunities. In public education right now, schools are more racially separated today than they were in 1953. That's not by law. It's by the activities of housing, where housing units are built. It's by zoning. It's by decisions about where to draw the lines between school districts. It's much more subtle than it was before. I think in response to that, it's understandable that many school systems, public school systems, created magnet schools to try to draw students from different backgrounds together, and often have included race as a factor in the selection. Is that a preference? It's trying to overcome a disadvantage.
And in some way, the court has condoned or validated the present culture.
Well, the Supreme Court has said when the patterns are a result of private decisions and not governmental decisions, then the Constitution does not apply. Because it is true that the 14th Amendment, enacted after the Civil War, protects people against discrimination by government. The problem is disentangling private preferences, government preferences. That's very, very challenging. When you talk about the pipes in Michigan, that's a